picture?
Yeah.
Oh, yeah, we gotta
So I'm going to
the
start
picture.
with a silly exercise because I'm a performance artist and we're about to dig into some kind of heavy, deep material. So I want to, before we do that, I want everybody to imagine that you're on a roller coaster and I'm going to take y'all's picture and put it on my social media just to follow the last session. So give me 1 second. All right, here we go. 1, 2, 3, everybody. Woo! Okay, thank you.
It's awesome. Well, I think we should start with your background. Yeah, Erica's a performance artist and she's awesome. So how about you tell us a little bit more about your background?
Sure. So I was born in New Jersey. Oh, you don't want to go back that far. That's good. I am an interdisciplinary artist here in town. I specialize in durational and endurance performance. If you're unfamiliar with that art form, probably the most famous durational and endurance artist is Marina Abramovic. I aspire to be at her level one day. Just keep on going. I'm also the executive producer of Aurora. If you're not familiar with us, we are DallasAurora.com. We are bringing back our biennial this year, so please keep November 18th in your books. I am, as was announced, the board chair of EASL, and we're going to dig into that a little bit more. And I'm also just a community advocate, y'all. You know, they talk about showing up. Show up. That's what we're doing today. Just be at these things. So I'm glad to see all of you.
Yeah. Okay, so I am an art lawyer. I am not a scary lawyer, I promise. I try my best. I have been on the board of Texas Accountants and Lawyers for the Arts for almost 12 years now. We have attorneys here. Symmetria Goodson's here, yay. And Gwen Seal. These are attorneys that are here today to help you. We are offering free consultations. You can sign up out front. We're going to talk about Texas Accountants and Lawyers for the Arts and the resources they have here today too. So my practice actually I'm at a firm called Carrington Coleman here. I lead the art law practice group. How I like to explain my legal practice is pretty much anything legal that touches the arts, whether that's visual, performance, music, entertainment, I handle. So we're going to talk about some really important resources you should know about, but also discuss some important legal things. I'm going to see how many I can squeeze in, but some things that you really have to know about your career that could significantly impact your career. So with that, I was going to see, Erica, if you wouldn't mind, tell us about EASL and what resources you provide.
So thank you. We are the Emergency Artist Support League. If you want to find us online, we're www.easl.us. We've been around for 31 years, but a lot of people are just now re-engaging with us. We are, as I said, an emergency granting program. We grant up to $5,000 for emergencies. There's a lot of stuff. Everything's online that I'm going to share with y'all today. So if I don't get it just right, it's there. The thing that I ask people that apply the most is ask for what you need, not for the full 5K. We are a volunteer-run board, and we do review everything, and we make fast decisions to address the emergencies. So our turnaround can be anywhere from 2 weeks to 3 weeks to address your emergency, because we deal with things like all of a sudden your rent went up, or an unexpected emergency like a pandemic. We dealt with a lot of pandemic, floods, you had a fall and you can no longer teach for the time being, and you have medical bills. Really, it's just about making your case of what your emergency is. We have other documents that we request. One thing that's very important, I apologize to all you performance art people in the room. We only work with visual arts and visual art professionals. There's some listing of what that is and is not. Like, we will do art films, but not your traditional films, stuff like that. And it's a pretty simple process. We cover 10 counties, so we're not just based in Dallas. You need to have 2 years of recorded history of being a practicing artist in the community or an arts professional. So things that you have to submit are like your CV, pretty simple, your website. We'll need to have proof of record that you live in one of these 10 counties. And another one of my recommendations is pay attention. If you're going through emergency, pay attention to everything that we need and try to deliver it as quickly as possible and complete. Because if you're missing stuff, then you're dealing with a back and forth with a volunteer board member, and then everybody votes. We don't worry about the convening in person. We're all about being as quick as possible for y'all because we are here for y'all. That's our main goal, is to make sure that we can get you to the other side. Just some stories. We literally were able to fund, we are totally anonymous, so if you don't hear me use artist names, that's because we can't. We don't want to air anybody's emergencies. That is up to them if they want to thank Easel. It also makes us really hard to market, which is why a lot of y'all, show of hands, who knows who we are? It's getting better. It used to be like one hand, I'll take it. But that's also why we have a marketing issue, because we're quiet. We don't want to be loud. But some of our artists over the last 3 years or so, we were able to help them get out of their emergency. They were able to show at the Nasher. We were able to help them get out of their emergency. They ended up at Tally Done because they could afford their materials and their supplies and the practice of being a practicing artist. Yeah, I could go through all the qualifications, but it's like 3 pages, so I'm not going to do that to you. But if you have questions at the end, I'm here, and I'm willing to answer any questions. But basically, Easel has been here for 31 years. We were started out of a conversation at a lunch that we didn't have any support system in our counties for an artist that, it basically started with a toothache. And it has turned into an unrestricted $5,000 fund that you can get once every 365 days, no more than a couple in your lifetime. So that's Easel.
Yeah, an amazing resource out there. Again, things happen, and to have that kind of support is so special. The clicker today. So Tala, so Texas Council on Lawyers for the Arts, we are here to provide another support as well. It is what's in the name. It is Accountants and Lawyers for the Arts. You can get accounting and legal services. We've been around since 1971. Has anyone here heard of Tala? Even less. Easel been winning. Yeah. So even less. Yeah. So this nonprofit, what we do, if you qualify for the services, you have an ability to get access to hundreds of attorneys and accountants. These are people that care very passionately about the arts, and they want to help artists. Some of these attorneys, y'all, they charge like $1,000 an hour, and they will provide free legal services. It's insane. The goal is to, and it's not just visual art. We focus and we help creatives of all mediums, musicians, performing arts. And we're going to talk a little bit. We even have a patent pro bono program where the United States Patent Office has selected our charity, one of the very, very few charities in the nation, to help creative inventors and help them get their ideas and inventions protected. So Tala is a great resource. You can find us at talaarts.org. So who do we help? We help artists of all mediums. We also help arts nonprofits as well. We know that arts nonprofits need legal advice too. Some of the services we provide. So there's a lot on this screen. I like to say, let's more focus on what we don't do, because pretty much all the other things we can do. Family law, we don't assist with. Litigation, if you're getting sued by someone, that's something that you're going to need to retain an attorney directly for. But we do have attorneys we can refer you to that would perhaps work on a discounted rate, maybe what's called a contingency rate. Contingency means the lawyers don't charge anything up front. They sort of get paid if the case is successful as well. We don't help with bankruptcy, criminal law, personal injury, tax audits, and we do not file individual tax returns. However, we will give tax advice and we have lots of clinics on that. And so we try to give you, and we talk about QuickBooks, other things. We try to give you as much resources as you can about your accounting. Copyright. I'm going to talk a lot about copyrights today here. We will help you protect your artwork, register your copyrights. We can help with sending cease and desist letters out if your artwork is taken. We can help form your company, form an LLC. How many artists here do we have that have formed their own company? Oh, this is awesome. It is not as scary as you think, I promise. But we help with that. Different contracts you're going to come across, licensing agreements, commission agreements. We help draft that and can help negotiate those as well. Non-disclosure agreements, if you're getting also represented by a gallery, there's gallery agreements. We also help nonprofits, help them to get started as well, and that can help with that paperwork as well. So there's a lot of things that TALA does. And what happens when you become a member, if you have a case, it's in limited access. I think the next slide is, I'll go back to this one. So if you are interested in becoming a member, you pay a fee of $75. That gives you access to as many legal questions as you have. There is not a cap, okay? But again, there's just some things that aren't part of the services that we can provide. But as long as you're in that group of things, you can call us as much as you want. What then happens is we have some amazing staff attorneys who will listen and try to give some advice to you up front. And if they think you do need a lawyer, then you go to our matching program, which is a database of hundreds of attorneys that volunteer. And we typically, we try to get cases matched as quickly as possible. Sometimes it may take a week. If it's an emergency situation, our staff attorneys are on the phone calling and trying to get it placed as quickly as possible. So the fee for artists is, like I said, $75 a year, $200 for a nonprofit as well. So that's fair, that's extremely reasonable. And then inventors, there's a different program through which it's about $100 for them. Back up here. So the patent pro bono program that we do, like I said, we were one of the very, very few selected nonprofits to assist with that. And the reason being is that the U.S. Patent and Trademark Office, which that's the government branch that files patents and trademarks, believe that inventors are creatives. And since TALA services creatives, we're probably the best place to vet these kinds of inventions and make sure that they meet a patent attorney and can get assistance with that. So how do you qualify? There are some financial limits to TALA. You have to be a Texas resident, anywhere in the state of Texas, okay? And you have to have your adjusted gross income, has to be below 300% of the federal poverty line. And based on 2023 numbers, we do have those figures up here, and it obviously increases for the size of your family household. It increases by about $15,000 for each individual member. Nonprofits, you have to have a budget of less than $200,000, and you qualify for those services. Inventors, if they're interested in the patent services, then there are some things you have to do, completing a prior art search. I'm not going to go into the things like that, but if you have an invention, the patent attorneys are going to get you routed to the right process and help you with those services as well. So some things that we have going on right now that I wanted to talk about is we have two upcoming events. One is called Arts Legal Line. This is, you can call and you have attorneys there to answer your legal questions. It is free. And the next legal line is May 2nd, so that's just right around the corner. We host those once per quarter, and our volunteer attorneys and staff attorneys are there to help. And as long as you qualify in that area of legal issues, we are happy to talk with you. The next event that we've got is Ask an Accountant, which, to me, taxes are, even though I'm a lawyer, that is very foreign to me. But if you ask an accountant, they're going to help you with bookkeeping questions, tax questions, budget questions, and we've got that Ask an Accountant on the next session is May 18th as well. So those are two upcoming events. TALA hosts a lot of programming. We're actually here today because the DAYL, the Dallas Association of Young Lawyers, gave us a grant to come help and talk to everyone today. But we provide educational seminars throughout the state of Texas. So I've got some more information about TALA here. Lisa McCain, she's not here today. She's our executive director, but we have Gwen Seal there in the back. She's here, and she's manning our booth right throughout the day too. We've got a sign-up sheet if you just want to get our newsletter so you can learn about upcoming events and things that we do. We have different educational seminars on our website. Our goal is to make the law less scary and help artists as much as we can with that. I've been able to help probably close to 100 artists myself just through TALA, and it's such rewarding work, and it's really cool. Just helping a little bit can really just change the trajectory of an artist's career in a totally different path. So that is TALA. And I'm actually going to, before I start going into some legal things you should know, and Eric and I talking about experiences we've had, I just want to see if there's any questions about TALA before I moved on, or EASL as well. All right. Okay. We did a great job explaining.
Our job, yeah.
We did great. Yeah. So I'm going to talk about two things today. Let me just look at my watch, how much time I got. Okay, we can do this. I'm going to talk about two really important things today. There is so much that you need to know legally about an artist, but I think these are the two most shocking things that most artists don't know about. So first question I have is, who has actually registered a copyright with the U.S. Copyright Office? All right, okay, we do have some. So when you create a work of art, once it becomes fixed in a tangible medium, so it's something that others can see, hear, watch, right? It's not an idea. It's got to be more than an idea of your head. It has to be something that people can experience. You have created a copyright. A copyright is something that has a lot of legal protections and is very, very powerful as an artist. You own that the instant that you create that. And what that means is you're the only one who can make derivative works, who can copy it, who can distribute it, who can license it. That's all stays with you. And so, however, in the United States, if you have to sue someone for copyright infringement, you can't do that unless you go and register with the Copyright Office. So, and it's done through they have an online portal. The process is not as scary as you're going to think. There's different forms for the different types of artwork that you need to protect. Literary has one form, audiovisual works have another, performance, choreography is another. You've got visual art as well. You can even, like, software programs will qualify for a copyright, which I won't go into that tangent, but you have to register it. And you can do so, you create an online account at copyright.gov, and it allows you to track everything and monitor everything that you've registered. And the process is things like, what's your name? Where's your address? When were you born? Like, how to get in touch with you with your artwork, what's the title of the artwork, and then you upload an image of or it could be a recording, could be a video, it just depends on what you're trying to protect. You upload that, you pay a fee. The fee is about $55. There's some caveats to that. I'm not going to go into all the details, but that's the process, and off it goes. And the Copyright Office will then start corresponding with you, usually electronically, if they have questions about what you're trying to register for that. So, why do you want to register? And there's some other things too, like Photographers have an ability to register up to 750 unpublished works. Like that's for photographers who have thousands and thousands of images, right? It can be impossible. You can't fathom what $55 per each application. There's also other ways where you can do about 10 works at once, called group applications as well, of unpublished works. And so there are some ways to try to reduce the cost for doing that. But when I'm talking with an artist and they've never registered a copyright before, they're always like, well, where do I start? Like, I have thousands of works I've created, and that can be really, that's a difficult conversation. But I try to say, like, what are your more significant works? I think those should definitely be registered. The ones that are getting a lot of attention, I think, if you are publishing these online, you need to have those works registered as well. And that's kind of what I say. Let's focus on that. It's a process, but it's worthwhile. The reason why it's worthwhile is when you catch someone stealing your work, the legal remedies change on whether it's been registered or not before that infringement has happened. So if the artwork is stolen and you have that copyright registered prior to, you can be entitled to something called statutory damages, and you can get attorney's fees, okay? And so the statutory damages, if the infringement is really bad, can go up to $150,000 per bad act, okay? So if the work is not registered, you do not have the right to statutory damages or attorney's fees, okay? What you're stuck with is what's called actual damages, and that's gonna be what the actual money you can prove that you've lost. That may not be a lot. It could just be a blogger just taking your artwork and putting it on their blog, and they're not making that much money, right? But the act of infringement is there. So you may be, by not having it registered on time, you could be missing out of making that decision of, well, is it financially better to claim actual damages, or is it financially better to go after statutory damages? And that registration isn't done timely. Unfortunately, you don't get to make that choice. So that's why I always say, register your copyrights, register your copyrights. I also teach at SMU. I teach a legal course for artists, and we spend weeks drilling and talking about the importance of your copyrights and registering those copyrights as well. The second topic I wanted to get into was work for hire agreements. Has anyone here signed or seen a work for hire clause, work for hire? So work for hire agreements, when you're hired for a project, when you're an employee for a company and you're doing something creative, you're a W-2 employee, right? The artwork you create in that scope of your job is going to be owned by your employer, okay? That's automatic. Whatever you do on the side at home, though, in the privacy of your home, that's your own creation, that's yours. But if you are an independent contractor, a freelancer, which most artists are, the rule is different, okay? The rule requires there to be something in writing where you are either transferring the copyrights in the artwork you're creating, or it's called a work made for hire, okay? So what happens is most people assume, just because I paid you for some services, I own the rights to that, and you are a contractor. That is not the case. That has to be properly documented in a written contract. And so it's something to kind of think about as you get hired for certain projects, like in commissions. So, for example, you're commissioned to do a sculpture, and you get the contract, and it's the commission agreement. They say, oh, here's the timeline schedule to create the work. Here's what we're paying you. But there's no language about it being made a work made for hire, and no language about you transferring the ownership of the copyrights to that artwork to the person that's paying you. Okay, well, they're just going to be they own the right then only to physically have that artwork in their possession, to display it, but they don't have the right to use commercially exploit it, okay? And that is a huge misunderstanding between people who commission artists and between artists themselves, is sort of this understanding that you've got to have something in writing. And so those are the two big topics I wanted to get into, but I also wanted to kind of talk too about sort of some horror stories as well and things I've seen. I know Erica's got some things too that that unfortunately, just I feel like artists are taken advantage of maybe a lot more than other professionals. It's in our nature to be giving and to want to create and want to share things with the world. A lot of artists also have a personality for sort of being more introverted and shy, and companies take advantage of that, and people take advantage of that. So every artist that I've worked with has had something bad happen to them, their artwork taken, or signed a contract they didn't know what they were signing, and so you're not alone. Don't be embarrassed if that happens. That is just going to be part of your career and learning experience. So you want to. I know that you had Eric and I were kind of workshopping some ideas on things we want to talk about, and I know that you have a lot of experience with working with galleries and institutions inside and outside, and kind of like your experiences and differences with that.
Yeah, I wanted to jump just real quick. I happen to be in a unique place that, like, I am an artist, but I'm also the person that delivers the contract to the artist. So understanding your copyright, who has it, usage rights, all that stuff, read the fine print. I get to make sure that clients understand that they don't own the work to use it all the time. But there isn't going to be a me behind every contract being delivered to a client. And they don't understand. So it's not even there, like, they just think they have it, it's theirs. So just make sure you read the fine print. If you don't know how to read the fine print, because it's in jargon, go to Tala or somebody else, because somebody will else be able to translate it for you. Mm-hmm. So I make a medium that's not very easy to understand. But what I have done for the last 15 years or so is I'm a collaborator. Collaboration is key. It's what we all want to do. We want to share, we care, and we believe in the creativity of others. What I haven't done, this is what I'm going to talk about, is please don't do what I've done, or haven't done rather. I have never delivered a contract to another artist that has been part of my copyright. What does that mean? We'll see what happens in the future, basically. Nothing's happened thus far, but that does leave me vulnerable and exposed. I have learned, thanks to, I now have legal representation as an artist, and I'm incredibly grateful because we're working through these things. But I've learned that in a collaboration, who shares the copyright?
Both. It's joint. It's equal. Yeah.
And I now have it in writing. But y'all, I'm in a position now where, okay, I wanted to enter this video into a competition for a prize. I have to get permission from that other artist. That's totally fine if that's the direction you want to go, but have the conversation up front. And that's something I've also learned. I think the biggest thing that I learned is lately, I didn't get any contract signed up front for an artist that I was working with that was making part of my performance, an element for my performance. We did a handshake agreement on cost. It came in 400% over the original handshake agreement. I had nothing to stand on. I had no paperwork, I had no emails, I had a conversation and my palm, and that gets you absolutely nowhere. So I have learned the hard way, keep it in writing. I know we're talking about copyright and stuff today, but I mean, just as an artist, I also think about liability. So I work with sometimes up to 100 volunteers for a piece. It's a small, tiny town. Just think about all your vulnerabilities. And also, if they were part of the piece, just as you said, collaborators, they have the right to a piece of it. And when I'm dealing with a small army of people, I need to really think about how that's all addressed. Even if it's just as simple as like understanding that you're working for this artist and they retain all the copyright. It can be that simple. But if I have lots of work, 25 performances out there, and I'm just now writing contracts. So y'all are amazing to be in this room today. I'm hoping that I don't have to deal with direct copyright infringement, but I do know a performance artist right now who did not file any type of tangible, because they do have video of the performance, but they found out too late that somebody had 100% replicated this performance up in New York City. So it happens. It even happens to us performance artists. And then just something on contracts real quick. I have never received a contract for an inside or outside performance when I have been brought in by an institution of some sort. That, I always thought, it's cool, whatever. No, not cool. So make sure you're thinking about these types of things. Traditionally, traditional mediums are dealing with like a consignment agreement or something of that sort when they're working with an institution, but it's not always the case. So protect yourself, protect your work. Not everybody is out there with a bad intention, but if something does happen, have it in writing.
And there's been, for a long time, galleries worked on handshakes. And there is now a shift happening with galleries.
Mm-hmm.
Galleries are wanting to get things documented. There's just, every gallery has been burned by an artist. Almost every artist in a gallery has been burned maybe by a gallery. And so there is a shift towards that. A lot of times I get calls from artists that are afraid they are handed a contract and they are afraid to push back or say anything, and some of those terms are really unfair. And look, those people are coming to you because they want your creation. You have the leverage here. You have the thing they want. And so it's okay to say no, and it's okay to push back, and it's okay to negotiate. There's nothing, you don't have to just accept it as is. A lot of times, though, it just depends on the situation. Your situation, like Sony wants to put your artwork in some commercial or something. You may have to decide, okay, do I really want to work with them? What's going to happen? Those are sort of business decisions, but you will not offend anyone by saying, I'm not okay with this, or I would like this term changed to. And something for contracts with artists, too, I see a lot is the commissioning party or the party that you're doing work with has an unrealistic expectation of your timeline, of how you can create, how long that's going to actually take, and how much money you need up front. Because when I see that my artists are getting paid in sort of installments as like milestones as the project, I always tell them, no, get as much upfront as possible, because you're going to be paying for all of the materials to do that work. You may have to pay for assistance. You may have to rent out space to complete the work. You have a lot of hard costs up front. So, and you run the risk of that person not finishing the payment plan, right? So get as much as you can upfront to make sure that if they walk away from the project halfway through, you're completely covered with all the costs that you've incurred personally on creating that work. And that's just, I would take a very, very hard stance on that, because, if someone's not, who's ever commissioning you they just don't know how you create work. They don't understand that. And it's not and just some education about that process will help. I've definitely negotiated contracts for huge murals, and the commissioning party is like, oh, we'll just pay like $5,000 down payment. I'm like, that won't cover the paint. Like, that won't, what are you talking about? Like, that you're asking the artist to come out of pocket on that, and they're already in the red. Which the margins may be already very slim. So definitely try to negotiate that and work with them so it's a reasonable timeline, because there are a lot of unreasonable expectations. I see this a lot too with like sculptures, like getting the sculpture made, and there's still supply chain shortages too, right? Of just getting the metal, getting the materials here, and being upfront with that commissioning party on that. But I did want to touch more on your collaboration too. And one of the things I do with my students at SMU at like the first day of class is I send a piece of paper around and I make every student in that class draw something on that piece of paper. And the point is to explain what is collaborative art and a joint copyright. So say I've got 15 students, they've all drawn on that piece of paper, and we've finished that piece of paper, one's drawn something. You now have a work of art, it's something tangible, that has a copyright to it. It's done, it's finished, you've now created a copyright. But all 15 of them now own rights to that same drawing. They all have the same equal rights, and they can all have the same equal rights of going out and marketing it, licensing it, making derivative works. Everyone's equal. Now you have to have an accounting and sort of, split the proceeds of profits 15 ways, but everyone is in that together, and so that can be very, very messy, trying to figure out, who can do what. And then let's say now you want to license that drawing, and it's going to, go on a T-shirt, right? Now all 15 have to sign off to approve that work can be licensed. So having these discussions about collaborations up front and figuring out who owns what and permissions is really good to have. And it's in our nature as artists to want to collaborate. That's what we do. We like being in a community. We like working together. And that I think is beautiful. But there's some legal ramifications to that, and so that's, and also interesting fact. So how long your artwork's protected? It's going to be your life, okay, plus 70 years, and then it goes into the public domain, and then it's out for everyone to use. I don't know if you're watching what's going on with Mickey Mouse right now and all of that. But I mean, Mickey Mouse is going to be tied up under copyright protection for a long time. It's not in the public domain, okay? There's a lot of different ways. It's not fully out. But when you do that collaboration art, right? So those 15 students, right? The protection of that artwork is going to last until the last survivor of all 15, who outlives all 15 plus 70 years. So that's something to keep in mind when you collaborate. Yeah.
And I just wanted to follow up with Andrea, just like with contracts. Don't be afraid to send them back with crossouts. I get them all the time, and just redline the paper and have the discussion. If they don't want to have the discussion, I will always have the discussion with artists. We do it as an organization, and a lot of it comes down to the pay structure, and we will negotiate and readjust because we understand. We work with all different types of installations, sculptures, new media, work that's commissioned, work that already exists. So just be your best advocate because, we're all cheerleaders for ourselves at heart. So rah, rah.
Yeah. Yeah. And I was trying to think of some more stories. The one that I usually frequently discussed in a presentation because it's just so heartbreaking and kind of like the extreme of what can happen, right? So the importance, like we talked in the first presentation about documenting your artwork, right, and sharing it, and something you should always do is make sure you put your copyright notice. So the copyright notice is going to be that circle C symbol, the year you created it, your name or company who owns that work, okay? And that is because that puts, even though you don't have that work, maybe you haven't registered that work, you're still putting the public on notice, okay? People know someone's claiming to be the artist, and so the inability, now that person can't say, oh, well, I didn't know, there was a copyright, or I didn't know this was, infringing, you've got that information right there. And I mean, for a lot of visual artists, it may just be on the back of the work. Like you don't necessarily have to put it on it. For photographers, a lot of times it's like a watermark on your digital images, right? Online, there's a lot of different ways for video, right? You just put the copyright notice in the video, right? So there's a lot of different ways that you can put that copyright notice on there. On your website, you can put the copyright notice as well for all the content and everything that's on your website. So I always recommend putting the copyright notice. That's not something that's required. You don't have to register to do that. That's automatic, a right that you have. This particular individual, who I care deeply about, incredible artist, painted a very famous mural in Austin. You know, Austin has their murals. They're, very famous mural in Austin. And about a couple years later after, and this artist did not put any copyright notice on that mural, okay? For whatever reason, they did not do this. And so a couple years later, this person starts getting phone calls of friends saying, hey, your mural's on a TV show, like Lady Gaga is sitting next to it. It had become set design. And that's something you have to pay for. Believe it or not, like set design, like I'm sure many of you know this, but like if your artwork shows up in a movie, it shows up in a TV commercial, shows up in a TV episode, that is something you have to get paid for. They have to license that from you, okay? Ai Weiwei was one who went after Volkswagen because they had used one of his huge installation works as a commercial for Volkswagen, okay? They didn't contact him or anything like that. So that is something that you deserve to be paid for. So we see what happens, and then we start seeing that, oh, this mural is like, literally every tourist shop that you can go into Austin has this mural as like coffee mug, apron, you name it. You can, buy it on art.com, all of that. But for the time being, we just wanted to focus on the TV show and getting that shut down and getting proper compensation for that. So we reached out to the TV show, and they had a really good defense. They said, well, try to figure out who the artist is. It's not registered. There's no copyright notice. We called around. We asked the property owner. We could not figure out who this was. They've got a very good defense. They did the reasonable things and due diligence to find the artist. They did that. Luckily, this program appreciates artists and artists' rights. And they said, I'm glad you called. Let's work out a deal. Let's make sure your artist is compensated for, okay? But if they had not been that way, we had a really, really uphill battle because they had some really good defenses. That information wasn't out there as it should have been, and the copyright was also not registered as well. So that turned out favorably, but it was pretty stressful, and we're thankful that we did have people that were compassionate about art. So,
We're doing on time.
We're good. We're probably time for Q&A if we want. We have some Q&A? Some questions? All right. I'll go front and then, okay, we'll go in the back.
I don't know how many times I can raise my hand or one question but my first question is, do we have any reports or legal support when we send proposals to galleries and nonprofit organizations and they have a town favorite that they pass the images and the concept of your proposal onto, and it replicates your own proposal?
Yes. Yes. Yeah. And so, like, if you're sending over images about your actual work of art, then yeah, that's yours. That is your copyright. And so if they're having someone else recreate that, that's going to be copyright infringement.
What about the concept of your proposal?
Like the idea, right? So, and that's going to transfer into different area law, non-disclosure agreements and trade secrets, okay? So what you've created is a trade secret. It's something that gives you a competitive advantage. It's something that is unique to your business and your creativity. And so, but that's also if you're sending out proposals for anything, any documents to anyone, put confidential on there. Put it at the footer and put confidential on that. And then you can, there's something called a non-disclosure agreement. And the non-disclosure agreement essentially, it says what we're sharing is going to be kept private. I have a specific one that I use that's real short, that's for when people are just talking. They're just conversing about potentially working together, and we're going to discuss potential collaborations. So, but if we decide not to work with each other, we're not going to steal each other's stuff. So, and a non-disclosure agreement is what you would send, and you could send that and say, look, I'm happy to share my proposal, here's a non-disclosure agreement, and that says things like they're not going to use it to their advantage and against your benefit, and they have to keep that information confidential. Yeah.
Is there any retro action that we can take in the event that we didn't have the Galleries or non-profit organization sign a non-disclosure?
Yeah, I mean, there is, it kind of, like, there's something called a statute of limitations too. So the statute of limitations by law, if you have a legal case, you only have a certain amount of time to bring that case. You can't just sit on it. And so, and that depends on the specific thing you're gonna sue for. And it can, sometimes it's 3 years, sometimes it's 5 years. Sometimes it starts, based on when you found out the bad action happened that hurt your rights. So that's going to depend. But like I said, it could be something with trade secrets. Like maybe if there's an email saying that this was to be held confidential, it is going to be fact specific. And that's meeting with a lawyer. They'll go through all the good and the bad facts, and then see. Give you a strategy and what they recommend on how to move forward with that. So, yes, front row here. Yeah.
So, in a hypothetical scenario, other than an office create something 2020 did not do the copyright, and 21 found out that there was infringement of the work, and then in 21 they did the copyright. Can they still sue and they get the
Oh, there's, yeah. Well, you've missed the if you haven't registered the copyright, you've likely missed the opportunity to get the statutory damages. But that doesn't mean you can't get the actual damages. So then you have to prove what was the actual profit made that you didn't receive, and so that's still available. That's still possible. So, and it's like you're that time frame is like
so
within the time.
So does the timing, you have to have it copyrighted before the other entity infringed?
Yeah, you have to register the copyright. If you want that statutory damages, there's little different rules there, but the main rule is you have to have that registration done before the infringement. Yeah. Yes. Yeah.
I wanted to ask you about copyrights in terms of social media.
Mm-hmm.
Because nowadays we post a lot of our artwork directly on social media. I think the rule is different. But I wanted to get a perspective on if you post your artwork on social media, someone uses it for a post or even uses the artwork, and you don't have it copyrighted. Are there any, what can you do about that? Like, what do you do?
Oh, yeah. Oh, this is great. I should include this as a third topic now that she said that. Takedowns. Those are fun. Okay, so so yes, that is copyright infringement. Just because you've posted on social media. Now, I'm talking about the big ones. I'm talking about Instagram, Facebook, Twitter. Okay, I don't. If you posted on some weird social media site and in a different country that says, if you post, you give up your rights. But let's talk about the ones that we all know about here in the U.S. and we work with. You don't give up your ownership of your artwork and your copyright, okay? So if someone is reposting that and not giving you credit, or you don't want them to do that, you can take that down, okay? And the easiest way to do this is Instagram, Facebook, Twitter, TikTok, they all have to, by law, they all have to provide a copyright agent and a procedure for you to notify them and say, someone is using my work and they don't have my permission. And because they're the portal for all of this, once they're notified, they're going to be at risk themselves for copyright infringement unless they address it reasonably, and if it does look like infringement, they take it down. It sort of protects them. They're an innocent party at that. It's like, oh, you told me, this goes for like Etsy, eBay, Amazon, all of that. So if that happens, then, things you could Google to find out, like you Google, copyright infringement notice Instagram. It's going to take you to that portal, and you can put in all the information. You have to send links about the infringing, like the URLs of the infringing site. And they move fast, like a couple of days fast. They move very, very quickly. And the process to get that reversed is not easy as well from the infringer side. It can take weeks, months. It can be very, very stressful. So what's called a takedown, DMCA takedown for Digital Millennial Copyright Act, that is sometimes when we realize the artist, there may not be a lot of profit in it, but the act is still wrong. It's more powerful to get their social media account shut down, okay? And then, like, even if there's been, this particular social media account that has had so many bad acts, they'll kick them off the platform, right? Mm-hmm. And so that, to me, may be more powerful and changing than, sending a letter and, trying to chase down money. So, yeah.
It also sounds like a sporting event, y'all.
I know, it's like, take down. Yeah. Yeah, it's something, and it's like, you can have an attorney help you with it, but they do try to make it user-friendly, so for anyone to do that. But they're all Facebook, they all have that, and they all have to have that, so, as well. Yeah, yes?
Okay, so you said there is a collaboration between, let's say, an artist and a clothing company.
Mm-hmm.
Both people own the copyrights. And then, so my question is, how do people negotiate royalties when it's the artist and the company? And then the second question is, should the artist do the copyright through their LLC if they have one, or under their personal name?
These are awesome questions too. So when you collaborate with a clothing company, they will not own your artwork unless you agree to, in writing, say, I'm going to give you ownership. They're licensing it from you, so they're just getting permission to use your artwork on their products. Okay. And so that then dovetails into what are royalties, and royalties are going to be the amount that you get paid off the profits that they're making from your artwork on their merchandise. Royalties they're all over the place. So there's not really a set percentage or amount to expect. It's really going to depend completely on, the market, how much they're selling, the artist, where they are in their career. Like Louis Vuitton, the new campaign that they have right now. You've all seen the polka dots, right? Like, that royalty is going to be a lot higher, right? That's and clothing companies do this all the time, where they collaborate with artists, right? Fashion designers do it all the time. And so it's just going to be kind of negotiating and trying to get some research on that, talk with friends, talk with attorneys, talk with other artists that have done that, reach out, and then you can kind of try to figure out what you want to get paid for, and what you're comfortable with and you think is fair. As far as putting that into an LLC, like forming an entity to run your business, that's a great idea, because that shields you if you've done that, if you form the company properly, and you're running. So this means you have to, like, your contract for that merchandise, you're going to be signing that in the name of the company, okay? And you've given the company the rights to be able to license your artwork. The goal of having this in like an LLC would be, if you were subject to a lawsuit, should not be personally at risk, okay? They're looking at the assets of the business themselves if something went wrong. There's things you could do to sort of lose that protection, like if you're not operating it like a real company, you're not keeping separate bank accounts, you're not filing your taxes for that company. But, I recommend LLCs a lot. I mean, they're my favorite business structure, especially for single, just like sole artists are just going to be the only member. They're really easy to set up. The filing fee in Texas is $300. And so I definitely recommend that. Yeah. So, yes.
Especially if you don't have to
Oh, we're out? Okay, we're out of questions. But, okay, if you have more questions, Tala is here, right? So we can continue the discussion if you have more questions. Thank you so much. Thank you, Erica.